I address to the body, I think I would like to perhaps discuss this in caucus. I'd like to raise the point as to how we treat the evidence presented by Her Honor the Ombudsman, and in connection with the PowerPoint presentation, given that the Ombudsman herself has cited Section 21 of the Ombudsman Law, Section 22 of the Ombudsman Law, which states her power to investigate for the purpose of filing a verified complaint for impeachment if warranted. So given the huge values involved in the presentation, I think we need to discuss how this will be treated, because if in fact it is the investigation was done in connection with a future verified complaint, then how are we as senator judges supposed to appreciate that in this impeachment court? I will not offer a suggestion for now, but I would like the majority floor leader to note that perhaps we should, well, I would like this to be discussed in caucus. And then the second point,
as I said, the situation is this. The Ombudsman did not come here voluntarily to testify. She was presented as a witness by one of the sides involved in this proceeding. And if I remember correctly, my rules of procedure and rules of evidence and the principles of trial, he who produces a witness must be bound by the testimony of the witness, whether favorable or adverse to him. So that's the situation.
His Honor's...
Even an illegally sourced evidence presented by one of the parties and not objected to is admissible.
His Honor's position is noted, and for that matter, though, I'd like to hear the views of my other colleagues in caucus on Monday. And then I just go to my second point, and I address this to the Ombudsman. Again, Her Honor mentioned her investigatory powers under Section 15 and 22 of the Ombudsman Law. And I would like to seek her opinion on how we reconcile this with a long line of cases by the Supreme Court interpreting Section 6 of Article 8 of the Constitution. Section 6 states that the Supreme Court shall have administrative supervision over all courts and the personnel thereof. And in connection with that constitutional provision, there are a line of cases, and I will quickly read a few provisions from these cases. In Judge Fuentes versus the Office of the Ombudsman, the Supreme Court said that it is the Supreme Court that is tasked to oversee the judges and court personnel and take the proper administrative actions against them if they commit any violations of the laws of the land. It further states in another case, Judge Coibis versus Ombudsman, the Ombudsman cannot dictate to and bind the court to its findings that a case before it does or does not have the administrative implication. To do so is to deprive the court of the exercise of its administrative prerogatives. Madam Ombudsman, I fully support the powers of the Ombudsman. In fact, I was one who raised my concerns and my frustrations over the previous Ombudsman's failure to investigate many offenses of impeachable officials. But I would just like to seek Her Honor's position on this, because again, we are groundbreaking, we are paving the way for, we are setting precedents for future impeachment proceedings. And has Her Honor had the opportunity to look at this so that we can, this will not be an issue today or in the future with respect to investigations of justices themselves? Because technically, let me just finish my statement, I'm sorry. If I look at the cases carefully, it would appear that the Ombudsman would have to refer these cases to the Supreme Court, and for the Supreme Court to determine or give the go signal for the clearance. So it seems to be a circuitous way of going about the investigation, but that seems to be the inclination of the Supreme Court, including a 2011 case, if I'm not mistaken, which involved retired Supreme Court justices.
Yes, Your Honor.
Thank you.
In the case you mentioned, Your Honor, in the cases you mentioned, those are administrative in nature.
Yes.
So the Supreme Court said that if the complaint, even if it were clothed with the nature of a criminal case, but it appears to be administrative in nature, then the Supreme Court, being
Having administrative supervision would
administrative
prevail.
supervision and control over officials and employees of the Supreme Court, then it should properly take cognizance thereof. Now, respecting your mention of an 2011 case, a recent case rather,
Yeah,
involving, I think you're referring to then retired and still retired Chief Justice Davide and Alice Austria Martinez.
Actually, I have not read the case itself. It was
Yes,
just given to me as
this case was filed by Oliver Lozano. He was assailing their decision in particular land case, and the Supreme Court said that the ultimate intention of the complainant was to modify or set aside their decision, and they cannot do that. So eventually, of course, the Ombudsman dismissed the case, and while the dismissal rendered the case before the Supreme Court moot and academic, the Supreme Court took time to lecture on the Ombudsman why it should not have taken jurisdiction on the case in the first place, because it was sought to question the way the justices rendered their decision.
I understand. So, in other words, Her Honor is basically confirming that in that case, what the Supreme Court laid down was the guidelines, and basically that was if the case is filed in connection with pending cases, it cannot be used to overturn those decisions. But we make a distinction. I assume that what Her Honor is saying, we make a distinction that if a case is an impeachment case, and for example, in this particular case, which Her Honor would pursue following reports on impeachable offenses, then that would not fall under the Supreme Court's administrative function.
It would not.
Is that what Her Honor is saying?
Yes, it will not.
Thank you.
Thank you.
Mr. President, may you recognize Senator Jing